A federal labor board says they're not just contestants looking for love, they're officially employees. That's how the NLRB says that people on the Netflix dating show Love is Blind should be classified in the board's complaint against the production companies behind the hit show.
The legal move is a first for reality TV. And of course, this show quickly became a hit by testing if people can fall in love without seeing each other. Watch it to see the answer to that. But Love is Blind is also testing the boundaries for worker protections on reality TV shows. Joining us now is Seth Berenzweig, a business and compliance attorney and white-collar defense lawyer. And Seth, listen, I think we're going to talk about what may happen here in the long run, but no matter what happens in the long run, is this filing some good news for contestants, at least in the issues that it raises and the fact that we're talking about this?
Well, it could be. We'll see what happens in the spring of next year, because in April there's going to be a hearing that's been scheduled in this case. But this is really a big deal, and it really caught a lot of people by surprise. The labor agency here in Washington has basically pulled a rabbit out of an employment law hat. They surprised everybody by coming in and really turning the law upside down by saying that reality TV contestants are employees, even though historically they have never been. And it has not been, probably because it is really not consistent with the traditional nature of an employer-employee relationship, where it's a more of a long-term type of business relationship where the employee falls within the scope of employment and performs regular duties for the employer, whereas on television someone is in a short-term relationship, usually as a contractor, and these are people who are in a contest that can really leave in the short term at will. So this was something that's very unforeseen and has really turned that part of the industry upside down.
Yeah, this show seems to specialize on short-term relationships. Seth, I wonder if you think that by any chance it would lead to contestants potentially trying to unionize at some point or to assert some more rights for themselves.
Yes, it could, but in order for that to happen, this hearing has to conclude in the spring, and it has to lead to a successful conclusion. One of the important background aspects of this case, which is also really interesting, is that you have a production company, Delirium TV, and I think it's actually ironic that their name is Delirium, because they must have been a delirium when they got themselves stumbled up with their antics to get caught in this case. They went after, in a heavy-handed way, a former contestant who had said some not very nice things in the background, and they slammed her with a $4 million plus lawsuit, trying to hold her liable under a non-disclosure agreement, injunction, attorney's fees, and all the rest. And really in reprisal and in sympathy for that contestant, the agency came in and slammed them back and has now retaliated with a complaint deeming this individual and similarly situated people on television as employees. Will it stand? It could. It also depends on what happens when the new administration takes over. But if this hearing does go forward, it can really fundamentally change the nature of how people are retained in the commercial space, especially as it relates to reality television.
Yeah, the NLRB says Love is Blind contestants should be paid for any lost wages while they're on the show. There were allegations about whether they were pushed too hard when it came to non-disclosure agreements. There's also an issue, how they're treated. And I think sometimes as viewers, people watch this stuff for its entertainment value, and it doesn't always occur to people as viewers that, oh, wow, this might have been kind of a terrible living situation or a terrible condition for this person, and this is bringing some of that into the light. And I wonder if you think some of these smaller protections, if any of these regulations, could they stand?
I really don't think it's going to end up applying, because it's really trying to fit a square peg into a round legal hole. Yes, if this theory prevails, there's going to be a whole panoply, a whole basis and layers of laws that would apply as if they're able to unionize. And in fact, the section of the Fair Labor Standards Act is part of the docket that says that this was the creative filing and the basis for it. But the problem is that these are long-term benefits and protections for people who are really on short-term media projects. So it's really difficult to see how this is going to work. But the agency didn't care because they found a very sympathetic plaintiff. And the thing that's really interesting about this is that this could even extend beyond reality television. There are a lot of different variants on right now in television and podcasting. What is this going to do? This could really overturn the entire apple cart in terms of employment law. So we'll have to really keep an eye on this. The Trump administration may really change this when their new general counsel comes into the board. They may try to pull the plug, but right now, this is something that could be a fundamental change in the entertainment industry.
Yeah, and how often do you have an incoming administration where a president knows a thing or two about reality television, as it were? Seth, thank you so much for your insight. Really interesting, and we will keep an eye on it.